Hello, all, and good day for you all, and welcome to another interesting session on PUL 342, Topic 4. Today, we shall be looking at judicial officers and penal theories. We shall be finding out looking at what judicial officers are as defined under Section 1 of the Criminal Code to include justices of the Supreme Court, Court of Appeal, the Federal High Court, State High Court, judicial officers, notary public, and justice of the peace. Okay, they also include commissioners of oath. Again, to continue with our class, I'm Dr. Akujobi, your facilitator for this class. Like I said, we're going to be looking at judicial officers for today and other topics under topic 7. We've mentioned just now that judicial officers definition is provided for under section 1 of the criminal code, where you also find out who judicial officers are. They enjoy powers which the law has conferred on them, and these powers varies and are limited to jurisdiction. Again, judges in their individual capacity can attest or direct the arrest with or without warrant of any person committing any offense in his presence. He may commit the offender for trial before another judge or even try the offender by himself. Section 31 of the Criminal Code provide that a judicial officer is not responsible for acts or omission done in his capacity, even if there's evidence that he acted maliciously. I think the essence of this is to protect the judicial officer to ensure that he does his work properly and in accordance with the provisions of the law. So, going to section 32, subsection 1 of the Criminal Code, that a person would not be criminally liable for any act or omission that is done in execution of the provisions of the law. So, provided you are acting within the provisions of the law, you are not criminally responsible for your acts or omission. However, section 32, subsection 4 says that it will not apply to acts or omission which would result in grievous bodily harm or death. So, what has to be also, despite the immunity provided in section 32.1, that immunity does not extend to those acts that lead to grievous bodily harm or death. So we know that a counsel is not liable to his client for negligence. I know, in as long as he's working as a minister in a temple of justice. So, what are those kind of things that makes one that in a judicial person acting in a judicial capacity? For instance, persons and body exercising when you are exercising your judicial functions, like a judge, a magistrate, and things like that. That during that period of proceedings, they are normally immune or they are normally not criminally liable for acts or omissions. Also, parties to the suit, but only in the course of judicial proceedings. Again, it is also possible. It is also analyzing the court. No, those are not what is required of a constructive criticism. So, for them to be constructive, they must not be seen to be either of those mentioned above. When a judge acts beyond proper judicial boundary, he or she may lose or forfeit his or her immunity. But where lies this boundary? How do we know the boundary? The law lays down no such boundary. It is probable, therefore, that no action may lie against a judge acting in judicial capacity. However, a judge or a magistrate may be criminally liable where he or she accepts bribe or bribe from, or he or she is found to be corrupt, to be corrupted, or to have acted corruptly in the course of his in his judicial capacity. Such behavior are obviously beyond one's judicial boundary. So, when asking that when can a judge become when can a judge go below his boundary? Of course, for instance, when he takes bribe or does such a thing, and an action brought against such a judge, the onus is on the plaintiff to prove on preponderance of probability that the judge acted beyond its jurisdiction. So it is. So that is one ground you can find the judge to have been liable, to have been wrong in whatever he has done. Again, the magistrate judge of the area court and other judicial officers are public officers. The statute or instrument under which the particular court are established also prescribe the condition of appointment and of removal from office of the judicial officers. Judges and magistrates on appointment must take the oath of allegiance as well as the judicial oath by which each of them promises to be faithful and to bear true allegiance to the Federal Republic of Nigeria, to discharge their duties, perform their functions to the best of their abilities, and act faithfully in accordance with the Constitution. So all of these are irrelevant, and that they will also not allow personal interest to influence their official conduct or official decision. Their purpose is to protect, defend the Constitution of the Federal Republic of Nigeria. So, having taken this oath of allegiance, a judge is expected at every time, at every given time, to exhibit certain qualities, which include integrity of character, patience, courage, and competence in the knowledge of the law. And also, you must be able to do justice without partiality or prejudice. So, in summary, Lord Mackay has said that they have put it as the quality of a judge are to give sound judgment based on knowledge of the law, a willingness to study all slides or all sides of an argument with acceptable degree of openness, an ability to reach a firm conclusion and to articulate clearly the reasons for the conclusion. So a lot behoves on the judge. He must be somebody that is good in the law. He must be somebody that is knowledgeable. He must be somebody that is competent. He must be somebody that is able to clearly give reasons for his judgment. A judgment cannot just stand like that. There must be reasons why that judgment is given. So, in summary, justice is all about being a pillar upon which the society rests. And the court, the law enforcement agent, must dispense it as its fundamental. The administration of criminal justice for both the superior court and the inferior court. Superior courts are courts we've mentioned in the past that includes the High Court, the Supreme Court, Court of Appeal, the Federal High Court, and the like. While the inferior courts are from the magistrate court downwards. Again, you should be able to tell the difference between one. One is that the judicial officers of the superior court can be found in the Constitution, which also prescribe their qualification and tenure and removal from office, while inferior courts are courts that are of state creation, and also they are also the laws creating them under the state also prescribes their power. So that's one of the basic difference between superior court and inferior court. Now, who are those persons that can institute criminal proceedings in Nigeria? We have the Attorney General, and that you can see under sections 150 and section 150 subsection 1 and 210, 211 of the Constitution for the state. So while 150 is for the federal, 211 is for the state. There are so many cases on this that provides for the functions, for the powers and duties of the Attorney General, and those duties of the Attorney General includes the duty to take over, to institute, to undertake, to continue, to discontinue at any stage of before judgment is given criminal proceedings. His powers are subject to, of course, to public interest. So the Attorney General has wide powers. You can imagine a person that can start a proceeding, can stop it anytime, can discontinue at any stage before judgment is given without being challenged. All he needs to do is to ensure that he's doing all to the in the interest of public, in the public interest. So, like I said, there are many cases to this. If you look out for cases on the part of the Attorney General, you definitely find them. Others that can prosecute are the police, the private prosecutor, and such prosecutors that, by virtue of the legislation creating the offense, are conferred with such powers, e.g., the custom officers under the Custom and Officers Act. So questions here are to differentiate between judicial officers in the superior court and those in the other court. Then again, what are the role of the judiciary? To ensure justice and to ensure things are done, and also ensure justice, ensure fundamental rights, ensure fair hearing, and to look into dispute between parties and ensure that those disputes are also properly resolved. So, again, one of the questions here again is to write a short essay on the magistrate court. An activity here has been provided, which the activity is that in practice, you have to assess um, in practice, access to justice is easier for some other than others. And for those unable to afford legal service, justice may be difficult to obtain at all. You have to discuss, or in discussion, you have to share your personal experiences or observations. So briefly we go to penal theories. Talking about penal theories, what do we have in mind? We are talking about those theories that um, have the theory behind punishment or the philosophy behind punishment. Is it to deter? Is it to serve as a deterrence? Is it to serve as reformation? Is it to serve as a form of retribution to others? So, again, all of this is to see how far these theories safeguard the existence of the society. How do these theories maintain order? Do they ensure that the citizens live uh, unmolested lives and are free from unlawful interference? Um, how far have these theories been effective under the law? So we don't look at these theories basically, or these views of punishment basically, which talk about retribution. That is talking about a just desert. The offender deserves his punishment. He has committed a crime and so he must be punished for the crime. Now, the justification given for the retribution theory is that punishment for offenders is both appropriate and fair. Since the offender has broken a law which others have refrained from breaking, and it is wrong, it is wrong that it should be left to go scot-free or obtain satisfaction from what he has done. Thus, the essential point of punishment is to restore an order of fairness which was disrupted by the criminal's criminal act. So you have been found to have committed an offense, and law says you should not go free to enjoy the satisfaction, to feel that yes, I've done what I feel like doing and nobody can do anything about it. No, others have refrained from doing it. You must not be allowed to enjoy to enjoy satisfaction from having indulged in a criminal act. So the whole essence of it is to ensure or restore fairness in the society, to ensure that if to ensure that whoever has committed it is dealt with so as others will not feel that because if nothing has been done to him, they too can go commit crime and enjoy the satisfaction of what they have done, um, what they shouldn't do. So we see another one that the third view is to restrain the offender physically so as to make it impossible for him to commit further crimes, at least during the period of confinement. The main aim of incapacitating, of restraining, is to ensure that the criminal is protected from the public, or the public is protected from the criminal. It is to ensure that the criminal is not let loose. Such a person is believed that if he's contained, if he's castrated, if he's contained, if he's amputated, or even disqualification, it might also serve as enough punishment for him. So if you find that when, like for instance, removing someone's license, driving license from him, so for that time period, or someone qualification license from him, so for as long as those licenses are removed from him, is incapable of committing further crime because he will not be allowed to drive, he will not be allowed to do other things. This appears to be one of the most effective forms of punishment. However, doubt has risen or been expressed as whether restraint or containment is not the postponement of the evil day. That whenever the person is finally being released, whether he will not go about still committing the offense. So, lastly, is that of rehabilitation. Again, this is also a form of punishment, a form of resocialization, with mind that such a person haven't gone through rehabilitation that emphasizes on reformation is able to trace his way back, you know, uh, become trace its way back, is able to return a person to his former state, you know, although again a criminal former state may also not have been a desirable one. So reformation is not just to reform, take you to your former state, but to take you back to a better state than you even were before. So if you were in a bad state before, like if you have been a criminal that has been caught, reformation or rehabilitation will be to make you a better person. Again, how effective is rehabilitation? It's been argued that it's quite effective as it produces some credible evidence that the offender no longer manifests these criminal propensities. So, if for from the above, it can be seen that for anything to be penal, it must have the following factors. It must involve pain or other consequences normally considered unpleasant. That is punishment for you. Anything that is called punishment and it's not, it does not kind of inflict some pains or some unpleasant consequences, that definitely is no punishment. Then it must be something, the punishment must be something against legal rules. Don't forget that it must be for an existing offense, for an offense that is being created by the law. Also, it must be from an offender, it must be to the accused person, the person that is guilty of the offense. It must be intentionally administered. It cannot be from an animal to a human being. It must be from a human being to a human being. And also carried out under a constituted, administered under a constituted authority. So the issue is, what does society seek to achieve by penalizing those who violate its laws, and whether or not the policies are fair and just. The sentences will be examined in order to see how effective it is. So we just go straight to sentencing now. What is sentencing? To note that sentencing are basically a disposition order of the court that involves imprisonment, fines, and things like that against the accused person. It could be in the form of death sentence, flogging, disqualification, compensation, reconciliation. So, except where the law makes it mandatory, the choice and question of sentencing is discretionary. The court will not impose a heavier fine or penalty than one that was applicable at the time the offense was committed. Basically, the court considers the following factors in giving passing out a sentence: nature of the offense, is it a simple offense, is it a misdemeanor, is it a felony, how grievous is the offense, if the offender is serial offender, has he committed several offenses in the past, is he still committing, and what kind of offender is he, has he been convicted for a similar offense in the past, what is the nature of that offense to the public. Is it in the public interest that that offense must be put an end must be put into it immediately, or is it a victimless offenses? And things, so many things to look out for. Prevalence of the particular offense, like we've mentioned above. Again, in talking about all of these basic things we must look for in the administration of justice, that the court must consider every defense open to the accused person on the evidence. Okay, every defense open to the accused person that have been put forward must be considered by the court. The whole evidence given during the trial must be taken and considered. The burden proving a fact which leads to the conviction of the accused person in criminal law is on the prosecution, and it is proved beyond reasonable doubt. However, there are few exceptions where the burden of proof is on the accused person. Any doubt as to the guilt of the accused person in criminal law must be resolved in its favor, as it is better to let go of an innocent person than to punish, or than to it's better to let go of 9 guilty persons than to punish an innocent one. Again, the findings of the court and conclusions from facts of a trial should be based on evidence adduced before the court and not on speculations or possibilities. So the court will normally act based on the evidence before the court and not otherwise. No court of law is entitled to draw conclusion of a fact outside the available legal evidence before it. Finally, we are to write a critique on the administration of criminal justice in Nigeria. You have to examine the rationale behind the different theories of punishment and their effectiveness. And finally, I put an activity here for you. What are the rights? What are the rights of a person charged before the court for an offense? So we'll stop here today, and please, before the next class, try to go through all of this so that we'll know what the areas you're having confusion in and all of that. Talking about rights of an accused person, go to your section 36 of the Constitution in order to find all the rights that are available to an accused person for an offense. Thank you for your time.